5 things to consider before becoming an estate executor. Before you say yes to being the executor of an estate, read this. Agreeing to be the executor of an estate is a bigger decision than most people realize. It is important to consider the responsibility of the position before agreeing to take on the role. Below are 5 things you should know before signing on. Key takeaways. While it is an honor to be selected as an executor, executing a will takes a lot of time and work. Make sure you can handle all that is involved before accepting the responsibility. When deciding whether or not to accept, consider the complexity of the estate, whether you have the time to devote to the immediate responsibilities required, as well as the multitude of duties that come into play when the testator passes away. 1. The complexity of the estate. Taking on the role of executor, also known as a personal representative, is not simply a matter of reading the will and using it as a set of instructions for distributing someone's assets. An executor essentially steps in for the testator, the person who wrote the will, and sees to all of that person's final arrangements, financial and otherwise. Generally speaking, the larger the estate, whether in terms of property, possessions, assets, or the number of beneficiaries, the more difficult and time-consuming it will be to disperse. For example, a house, several bank accounts, a stock portfolio, and possessions will all have different steps to dispersal and hurdles to clear, like completing tax documents. This is why high net worth individuals usually use professionals to both set up an estate plan and then help execute it when they pass on. That said, even small estates with only a few beneficiaries can become problematic if just one person contests the will or is otherwise inclined to throw a wrench into the process. The best way to assess how difficult the job will be is to ask to see a copy of the current will or a draft of the will if one is in the works. If there are obvious red flags, unequal distributions to children, trusts, or annuities to untangle, or anything else you feel uncomfortable handling, you might consider passing on the responsibility. 2. The time commitment. Being an executor takes time and energy and requires a lot of attention to detail. In fact, it is almost solely concerned with details. Before you agree to be executor, you should be certain that you have the time to do the job. If you have a busy professional life or a lot of family commitments, it may be difficult to set aside the needed time. It is important to make a decision based on your current situation. As long as the testator is alive, you can be added or removed as the executor of the estate. You can also request a co-executor or professional help. However, you will not be able to appoint someone else if you find out you don't have the time after the testator has passed away. If you don't live near the testator or move out of state, that's something to consider as well, as you may need to travel to the testator's home state to handle paperwork and other matters. It is important to review your decision to serve as an executor every time your situation changes significantly. You get married, have kids, get older, etc. It is natural for a testator to change executors throughout a lifetime. It is far better to decline the honor of becoming an executor of an estate for the right reasons, the inability to do the job properly, than to take it on for the wrong ones, a sense of obligation. 3. Immediate responsibilities. Some people agree to be an executor thinking that it will be years before they have to do any work. However, doing the job properly means going to work immediately. You'll need to be ready since your legal responsibility could be called upon at any time. To prepare for the task, you should do the following before the testator dies. Make sure the testator keeps an updated list of assets and debts, including bank and investment accounts, insurance policies, real estate, etc. Know where the original will and the asset list is being held and how to access them. Know the names and contact details of attorneys or agents named by the testator and what their functions are. Discuss the testator's wishes as far as a funeral or memorial service, including instructions for burial or cremation. Discuss the will with the testator and, if possible, with the beneficiaries in order to minimize problems in the future. Have a copy of important documents such as the will, letter of intent, and any powers of attorney. It may be helpful to consult an estate planning checklist to make sure you have everything you need. 4. Duties after the testator dies. Of course, the real work starts when the testator passes away. It is then that the executor is called on for funeral arrangements, locating and filing the will, clearing probate, managing assets, clearing debts, submitting tax returns, establishing and managing any trusts, responding to legal challenges, and more. Being an executor requires you to carry out the details of the will and comply with legal requirements. It's important to be organized and detail-oriented. Even if you aren't naturally inclined to be so, the estate will pay reasonable costs for professional help. That said, you will still need to be involved at every stage. 5. How you will be paid. Each state has laws determining how an executor is paid. It can be by the hour, as a flat fee, or as a percentage of the estate. Sometimes the fee is determined by the probate court judge. In addition to the regular fee, there may be an extraordinary fee if an unusual amount of work is involved. For example, selling off personal property or managing litigation on behalf of the estate. The testator is permitted to state in the will how they want the executor to be paid, and that may override applicable state law. Executors are also entitled to compensation for expenses incurred as they carry out their responsibilities. Payment is made from the estate after all the bills are paid, but before any money goes to the beneficiaries. If being an executor is likely to take a major portion of your time and cut into your ability to do your regular work, it's especially important to get some sense of how you will be compensated. And remember, this payment counts as income and must be reported on your tax return. Executors are also permitted to refuse compensation. For example, if you were doing this task for a member of your family and want the whole balance of the estate to go to the beneficiaries. The bottom line, it is an honor to be selected as an executor. It signifies that the testator trusts you to carry out their final wishes and to see to their legacy. However, only you know if you are up to the challenge of a particular estate, so it is important that you accurately size up the task as well as your personal situation before committing to do it. Remember, there are always other options. The testator can always find another person or assign multiple executors or agents who each specialize in a particular area. What's the average cost of making a will? Let's face it, the last thing people want to do is plan for their death. There are a lot of important decisions you need to make, decisions you shouldn't leave to your loved ones. These include saving for and planning your funeral, appointing a power of attorney, designating beneficiaries for all your accounts, setting up your kids, especially if they're fairly young, planning your estate, and setting up your last will and testament. This last one is probably one of the most important things you'll have to do. Below, we've outlined some important things you'll need to consider when you're putting together this important document. Key takeaways. Setting up a will is one of the most important parts of planning for your death. Drafting the will yourself is less costly and may put you out about $150 or less. Depending on your situation, expect to pay anywhere between $300 and $1,000 to hire a lawyer for your will. 1. While do it yourself, will kids may save you time and money. Writing your will with a lawyer ensures it will be error-free. A complicated process. Drawing up a will isn't as easy as you may imagine. Most people hear the word will and think it's a fairly simple process. The idea most people have is that it requires a few minutes to designate the recipients of all your worldly belongings. But that isn't true. In fact, there are many important facets to the document you have to consider, right down to how you word it. If you have a lot of assets, run a business, and have more than one child or grandchildren, you need to take some time to make careful decisions about what happens after you die. Doing so now will help those you leave behind in the end. Make a list of all your assets, your home, vehicles, any valuables, along with all of your financial accounts, such as checking and savings accounts, certificates of deposit, deeds, and life insurance policies. Then jot down all of your dependents and who inherits each asset. Also note that if there are any special considerations you'd like to include in your will, such as when minors inherit your assets, how accounts will be split up, or what happens to your home after you die. You can try drafting the will yourself, or you can hire a lawyer to do the work for you. But even if you hire an attorney, you'll still have to make these important decisions on your own. We'll look at the benefits and drawbacks of both a little later in this article. The cost of a will. The fee for having a basic will written can be as little as $150. Fairly reasonable and affordable for most people. Consider purchasing a do-it yourself will creation kit that can be purchased online or in stores for less. These are generally templates you can fill in with your pertinent information online. If you require more complicated or additional estate planning documents, be prepared to dish out more cash. It can cost $1,000 or more in advanced situations, but this may be too generic for you, leaving you the option to hire a professional. If you do hire a lawyer, though, you should be aware that it's going to come at a price. The low end for having a lawyer draft a will is around $300, but it can easily cost $1,000 or more if your situation is more complicated. Do it yourself. Do it yourself kits to create and file a legally enforceable will have gained in popularity due to the minimal cost involved. If you don't have a lot of complicated issues about your final wishes, your finances are fairly straightforward, and you don't have any children, this may be the most suitable option for you. Kits can be purchased for as little as $10, so they give you the option of drawing your will at your convenience without having to pay an outrageous cost. There's a lot less time involved, and you can generally make updates at your leisure without much difficulty or cost. Before you settle with one of these kits, first read the reviews of the platforms selling the kits and hear what their customers say about this product. This is a new business, and many companies are racing to take a share in it while the quality varies from the legal providers. Second, make sure you understand everything the kit entails, including the legal language. You don't want to sign a document you don't fully understand. Also consider whether the document is enforceable in your state, as some documents don't coincide with guidelines in certain areas. For the state compliance matter, contact the platform and ask them the question and get their experience with other users from your state. You may be required to have witnesses or have your document notarized. Remember that the basic will documents within may not cover every life situation that should be addressed. That's when you move to the next step. Hire a lawyer. This is the best option if you have a complicated situation, a lot of assets, many beneficiaries, and a lot of dependents. While the decisions of what happens to your estate after you die are yours, an attorney can guide you through the process and help you word your will properly, so there are no mistakes. After all, you are paying for legal advice, so it makes sense that you get the full benefit of an error-free will. Keep in mind, though, hiring a lawyer to draft a document may cost anywhere from $100 per hour to $400 per hour or more. And if you decide to make any changes, it will cost you because it means another trip to the lawyer. Regardless of whether you write the will yourself or hire a lawyer, the decisions about what happens to your estate are yours alone. Will Vs. Living trust. There tends to be some confusion between wills and living trusts. Many people believe these are one and the same, but they're not. A will covers how assets are distributed after your death and allows you to appoint a guardian for any minor children. A living trust, on the other hand, is a more comprehensive estate planning tool that covers not just the issues that a will addresses, but also allows for the establishment of medical and legal power of attorney if you become incapacitated. It also appoints a successor trustee to handle any legal and financial matters upon your death. 2. Living trusts typically cost $1,000 or more to establish, but are considered more complete planning tools compared to a will. 6. Estate planning must-haves. Everyone benefits from ensuring assets and finances are managed as they wish. Many people believe that having an estate plan simply means drafting a will or a trust. However, there is much more to include in your estate planning to make certain all of your assets are transferred seamlessly to your heirs upon your death. There are specific estate planning documents, like healthcare power of attorney and will or trust. A successful estate plan also includes provisions allowing your family members to access or control your assets should you become unable to do so yourself. Key takeaways. Estate planning is not only for the wealthy. Everybody can benefit from ensuring their assets and finances are properly taken care of after their death. Without a will, a probate court could lead to an unintended distribution of assets. Estate planning is also useful if you become incapacitated. A will is part of an estate plan. If you have underage children, an estate plan is extremely important, as it will list their guardians in the event your spouse cannot care for them after your death. Estate planning basics. The estate planning must-have. Here is an estate planning checklist of items every estate plan should include: will trust, durable power of attorney, beneficiary designation, letter of intent, healthcare power of attorney, guardianship designation. In addition to these 6 documents and designations, a well-laid estate plan also should consider the purchase of insurance products, such as long-term care insurance to cover old age, a lifetime annuity to generate some level of income until death, and life insurance to pass money to beneficiaries without the need for probate. Does your estate plan measure up? Let's examine each item on this checklist to make sure you haven't left any decisions to chance. 1. Wills and trusts. A will or a trust may sound complicated or expensive, something only rich people have. That is an incorrect assessment. A will or trust should be one of the main components of every estate plan, even if you don't have substantial assets. Wills ensure property is distributed according to an individual's wishes if drafted according to state laws. Some trusts help limit estate taxes or legal challenges, however. Simply having a will or trust isn't enough. The wording of the document is critically important. A will or trust should be written in a manner consistent with how you've bequeathed the assets that pass outside of the will. For example, suppose you've already named your sister as a beneficiary on a retirement account or insurance policy, assets that typically pass outside of a will to a named beneficiary. In that case, you don't want to bequeath the same asset to a second cousin in the will, because it could lead to a will contest. Not to mention that both individuals could become bitter toward each other and you during a legal battle. Always name a guardian and a backup guardian for your underage children in your will. If you do not name a guardian, the courts may decide to place your young children with a family member, not of your choice, or even put them in the state's custody. 2. Durable power of attorney. It's essential to draft a durable power of attorney, POA, so an agent or a person you assign will act on your behalf when you cannot do so yourself. Absent a power of attorney, a court may be left to decide what happens to your assets if you are found to be mentally incompetent, and the court's decision may not be what you wanted. This document can give your agent the power to transact real estate, enter into financial transactions, and make other legal decisions as if they were you. This type of POA is revocable by the principal at a time of their choosing, typically when the principal is deemed to be physically able, mentally competent, or upon death. In many families, it makes sense for spouses to set up reciprocal powers of attorney. However, it might make more sense in some cases to have another family member, friend, or a trusted advisor who is more financially savvy act as the agent. 3. Beneficiary designations. As noted earlier, a number of your possessions can pass to your heirs without being dictated in the will. EAG 400K. Clan assets. This is why it is important to maintain a beneficiary and a contingent beneficiary on such an account. Insurance plans should contain a beneficiary and a contingent beneficiary as well, because they might also pass outside of a will. If you don't name a beneficiary, or if the beneficiary is deceased or unable to serve, a court could be left to decide the fate of your funds. And frankly, a judge who is unaware of your situation, beliefs, or intent is unlikely to make the same decision you would have made. Over 21. Named beneficiaries should be over the age of 21 and mentally competent. If they aren't, a court may end up getting involved in the matter. 4. Letter of intent. A letter of intent is simply a document left to your executor or a beneficiary. The purpose is to define what you want to be done with a particular asset after your death or incapacitation. Some letters of intent also provide funeral details or other special requests. While such a document may not be valid in the eyes of the law, it helps inform a probate judge of your intentions and may help in the distribution of your assets if the will is deemed invalid for some reason. 5. Healthcare power of attorney. A healthcare power of attorney, HPP, designates another individual, typically a spouse or family member, to make important healthcare decisions on your behalf in the event of incapacity. If you are considering executing such a document, you should pick someone you trust, who shares your views, and who would likely recommend a course of action you would agree with. After all, this person could literally have your life in their hands. Finally, a backup agent should also be identified if your initial pick is unavailable or unable to act at the time needed. 6. Guardianship designations. While many wills or trusts incorporate this clause, some don't. If you have minor children or consider having kids, picking a guardian is incredibly important and sometimes overlooked. Make sure the individual or couple you choose shares your views, is financially sound, and genuinely willing to raise children. As with all designations, a backup or contingent guardian should also be named. Absent these designations, a court could rule that your children live with a family member you wouldn't have selected. And in extreme cases, the court could mandate that your children become wards of the state. What is an estate plan? An estate plan is a collection of documents and includes a will, guardianship designations, healthcare power of attorney, beneficiary designations, durable power of attorney, and a personal letter of intent. outlining your wishes should you die or become incapacitated. Do I need an estate plan? Not everyone needs an estate plan, but everyone should have a will, which is a key component to an estate plan. However, estate planning can be done no matter what your financial status, as it includes important information like naming guardians for your underage children and ensuring your assets go to your named beneficiary. What happens if I die without a will? If you die without a will, your estate will end up in probate court, and the courts will decide who will inherit your possessions and assets. The bottom line: a will is a great place to start, but it's only the beginning. There is more to estate planning than deciding how to divvy up your assets when you die. It's also about making certain your family members and other beneficiaries are provided for and have access to your assets upon your temporary or permanent incapacity. Letter of instruction. Don't leave life without one. This document helps your executor and heirs fulfill your wishes. A letter of instruction is a cheat sheet for anyone involved in settling your affairs. Unlike a will, this letter has no legal authority. However, it can provide an easy-to-understand explanation of your overall estate plan to your executor and lay out your wishes to your family for things not covered by the will. A letter of instruction can help to simplify a complex inheritance structure for your heirs. But you don't need to have a complicated estate to benefit from one. For example, your letter of instruction could outline who should get items that aren't necessarily valuable but might be sentimental. It can also make things easier on your family by laying out a complete picture of your assets, as well as listing the locations of important documents. One great advantage is that because these letters aren't legal documents, you can include your own personal wishes and messages to your family. Here's everything you should include in your letter of instruction and an overview of what it can and can't do for you. Key takeaways. A letter of instruction may be used to lead the person settling an estate through a step-by-step process in plain language. The document can augment your regular will or leave personal messages for your loved ones. As with any other estate planning document, a letter of instruction should be updated at least annually and kept in a safe place. It should be easily accessible by your relatives or executor. What does a letter of instruction include? A letter of instruction provides specific information regarding personal preferences in medical or funeral care, as well as details concerning dispersion or care of personal assets that legal documents may not be able to outline. Letters of instruction can be used for many different reasons, but one main use is simply to lead the person settling your estate through the process, step by step, using plain language. A letter of instruction has no legal authority, but it can provide an easy-to-understand explanation of a person's overall estate plan to their executor. A good letter of instruction should contain the following information: a complete list of all assets, the whereabouts of any tangible assets that are not readily accessible, necessary information about all liquid assets, including bank, brokerage, retirement, and investment accounts, the names and contact information of any bankers, brokers, attorneys, or other professionals who handle your assets, informal information regarding the dispersion of assets, such as who would get a sentimental possession or heirloom. The will may state that these articles are to be distributed according to the letter. Preferred charities for donations if they are expected. The location of legal and financial documents such as bank and social security statements, tax returns, birth and marriage certificates, divorce and citizenship papers, social security card, titles and/or deeds for any real estate properties, wills, and trusts. A list of all financial account beneficiaries or other estate beneficiaries and their contact information if necessary. The location of all safe deposit boxes and their keys. The contact information of any debtors such as mortgages, credit cards, and car loans. Details about and contact information for any and all insurance coverage, especially life insurance. Instructions for the care and placement of any pet. Keep your letter of instruction up to date. This letter can also outline more personal desires. For instance, details about where you want to be buried and the kind of funeral you want. You can specify the location, funeral home, and even the type of flowers you would like, or whether you would like your body or ashes to be displayed at the ceremony. You can also use the letter to voice personal requests that may be inappropriate for a will or trust, such as a general sentiment about how you would like your heirs to use their inherited asset. You can also state preferences about what happens to your digital footprint, such as instructions for your social media accounts. Another advantage is that you can use the letter to expand on your living will, elaborating on the medical conditions under which you would like to be taken off of life support in more detail than is permitted in a medical or healthcare power of attorney. Many people also include an ethical will, a document that allows you to pass down your values, beliefs, and ideals to your loved ones. Inside this letter, remember, this type of letter does not have to meet any kind of legal format or other formal requirements. It can be handwritten on plain notebook paper and kept in a file drawer if you like. In a letter of instruction, anything goes. Micromanagers can even use these letters as a chance to write their own obituaries. The bottom line, a letter of instruction provides a helpful guide for those who will have to settle your affairs once you are gone. As with any other estate planning document, it should be updated at least annually and kept in a safe place where it is accessible by your relatives or executor. While this letter is not required in any technical sense, it can serve as a final gesture of consideration for those you have elected to settle your affairs.